Get ready for the dictation. Start. If the plea as advanced by the learned counsel has to be agreed to, then it shall mean that between May 15, 2015 and July 2017, the respondent, after taking or seeking the benefit of the petitioner's experience in building the hotel just before the start of operation of the hotel, could have terminated the agreement, leaving the petitioner in lurch or high and dry to its prejudice. In fact, the stipulation was in the interest of the petitioner against such termination. Further, the plea of the learned counsel is on a misreading of the stipulations in the agreement, inasmuch as Article 24(1) states the agreement shall commence upon execution of the agreement by the parties and shall continue in force for a period of 15 years commencing from the opening date of hotel. Similarly, Article 24(3) clearly state the first 5 years of the terms of contract starting from the effective date shall be considered as a lock-in period. On a reading of both clauses, the position emerges: 1. The agreement shall commence upon its execution by the parties. 2. The first 5 years of the terms of contract starting from the effective date shall be considered as a lock-in period. 3. The 15 years shall commence from the opening date, that is, commencement of operation of hotel, July 2017, and 4th, the first renewal of 10 years shall be after the term of 15 years from opening date. Learned counsel is right in stating that the interpretation sought to be given by Mr. Dutt is contrary to the express terms of the agreement. It is prima facie clear that the lock-in period of 5 years had commenced on May 15, 2015, and the notice being of July 28, 2020, which is after the lock-in period of 5 years, the same is proper. In view of the above conclusion, the reliance placed by Mr. Dutt on the judgments in the cases of Gujarat Bottling Company Limited and others, and Ascot Hotels and Resorts Private Limited and others, shall not be applicable in the facts of this case, inasmuch this court in the country development and management, by relying upon the apex court judgment in Gujarat Bottling Limited, on which reliance has been placed by the learned counsel, has held that the relief by way of interlocutory injunction is to protect the plaintiff against the injury of violation of his right, for which he could not be adequately compensated in damages recoverable in the action. The need for such protection has, however, to be weighed against the corresponding need of the defendant to be protected against injury resulting from his having been prevented from exercising his own legal rights, for which he could not be adequately compensated. Whereas in the case in hand, there is no stipulation that the agreement cannot be terminated even after lock-in period. In other words, it is determinable contract. That apart, the justification of the respondent is by relying on the stipulation of underperformance of the petitioner for 3 years. Whether there was underperformance, who was responsible for the same, cannot be decided in these proceedings, but to be decided by the arbitrator, and the petitioner can be adequately compensated in damages if it succeed before the arbitrator. It is not the case of the petitioner that damages shall not adequately compensate it. Prima facie, the action of the respondent cannot be faulted. Learned counsel has rightly relied on the judgments in Royal Orchard Hotels Limited and Marriott International Incorporation and others, wherein the court has held that in view of Section 14(1) of the Amended Act of the Specific Relief Act, the contract under the following category cannot be specifically enforced. The reliance placed by Mr. Dutt on the judgment of this court in Ascot Hotels and Resorts Private Limited and others is misplaced, as it is not applicable to the facts of this case, inasmuch as in the said case the appeal filed before this court was against an interim order passed by the learned arbitrator directing the parties to maintain status quo with respect to licensed area. This was primarily on the basis of clause 22.4 of the license agreement therein, which stated that Ascot can terminate the agreement except in the event of any 3 consecutive defaults by respondent CPRL to pay license fee and failure on the part of CPRL to make good the default. It was the case of CPRL that there was no default in the manner prescribed in clause 22.4. This plea was accepted and the status quo order was not interfered with. Similarly, the judgments relied upon by Mr. Dutt in the case of Adani Power Limited, Shandvik Asia Private Limited, in support of his submissions that nomenclature in an agreement is not important and agreement has to be interpreted harmoniously, giving effect to intent of the parties, have no applicability, as the said judgments are distinguishable on facts and in view of my conclusion above. Even the plea of that the respondent could not have terminated the agreement stop.